An Introduction to Constitutional Law, 100 plus Supreme Court cases everyone should know, by Randy Barnett and Josh Blackman. Affirmative action on the Berger and Rehnquist courts. Regents of the University of California versus Bakke, 1978. Gratz versus Bollinger, 2003. Grutter versus Bollinger, 2003. Most law students are familiar with the concept of affirmative action, but likely do not know the phrase's origin. In 1961, President John F. Kennedy issued Executive Order number 10925, which barred government contractors from engaging in racial discrimination. The order, however, did not simply prohibit discrimination. Rather, it provided that contractors, quote, will take affirmative action to ensure that applicants are employed and that employees are treated during employment without regard to their race, creed, color, or national origin. That is, positive steps must be taken above and beyond race-neutral hiring practices to increase employment of minorities. The Supreme Court would consider the constitutionality of affirmative action in higher education in Regents of the University of California v. Bakke, 1978. Alan Bakke, a white man, was denied admission to the medical school at the University of California at Davis. At the time, there were 100 seats in the entering class. 16 were set aside for minority applicants. Bakke could not compete for those spots. Bakke argued that the quota system violated the Equal Protection Clause of the 14th Amendment. He also claimed that the admission policy violated Title VI of the Civil Rights Act of 1964. That statute prohibited racial discrimination by schools that accept federal funding. The Supreme Court sharply divided in Bakke. The breakdown was somewhat confusing. 4 justices found that race-conscious affirmative action policies did not violate either the Equal Protection Clause of the 14th Amendment or Title VI. Justices Brennan, White, Marshall, and Blackman would have upheld the admissions policy in its entirety. 4 other justices did not reach the constitutional question because they found that Davis's race-conscious policy violated Title VI. Chief Justice Berger and Justices Stewart, Rehnquist, and Stevens. Justice Powell was somewhere in the middle. He found that Davis's race-conscious policy was unconstitutional. However, he also found that race could be used as a factor, among others, in admissions as a means to obtain educational diversity. With this, Justices Brennan, White, Marshall, and Blackman concurred. Justice Powell's diversity-based rationale was the most narrow opinion. Therefore, it was the controlling one. He observed that, quote,
the Davis Special Admissions Program, with 16 of 100 seats reserved exclusively for 3 categories of minorities, is a classification based on race.
He continued,
that a racial classification by a state agency is inherently suspect and must be subjected to the most exacting judicial scrutiny.
However, Justice Powell thought that an admission policy could satisfy strict scrutiny if it considered race to promote educational diversity.
Our cases have held that some distinctions are justified if necessary to further a compelling state interest.
The university argued that it had a compelling interest
to redress racial imbalance said to result from general societal discrimination against the minority groups selected for preferential treatment.
Justice Powell rejected this rationale because
there is a complete absence on this record of any finding that this imbalance is traceable to discriminatory practices. Discrimination by society at large, with no determined effects, is not sufficient to justify petitioner's racial classification.
However, Justice Powell found that
The only state interest that fairly may be viewed as compelling on this record is the interest of a university in a diverse student body. This interest, encompassed within the concept of academic freedom, is a special concern of the First Amendment.
there was only one interest that was compelling enough to justify a racial classification: the educational benefits that flow from a diverse student body. However, the University of California's quota system did not meet that standard. The university's quota system
Totally excludes all applicants who are not Negro, Asian, or Chicano from 16 of the 100 seats in an entering class.
Therefore, the university's policy
Arbitrarily forecloses all competition solely on the basis of race or ethnic origin is not necessary to attain reasonable educational diversity.
In contrast, Justice Powell praised
The Harvard admissions program as one example of how race properly, in my opinion, may be taken into account.
Harvard University did not set a quota. Rather, Justice Powell found
Race is considered in a flexible program designed to achieve diversity, but it is only one factor weighed competitively against a number of other factors deemed relevant.
to survive strict scrutiny then,
Race may be considered as a relevant factor.
ultimately, Bakke was admitted to Davis and graduated from the medical school. The precise holding of Bakke and the status of Justice Powell's solo concurring opinion would remain unclear for the next 25 years. In 2003, a majority of the Supreme Court finally adopted his diversity rationale in a pair of affirmative action cases from the University of Michigan. The first case, Gratz versus Bollinger, challenged the university's undergraduate affirmative action policy. The second case, Grutter versus Bollinger, challenged the law school's affirmative action policy. The university's undergraduate admissions office assigned a numerical value to an applicant's race. Chief Justice Rehnquist described the process.
The current program employs a selection index on which an applicant can score a maximum of 150 points. A score of 100 points guarantees admission. Each applicant receives points based on the factors considered by the OUA.
The university would award an applicant points based on high school grade point average, standardized test scores, alumni relationships, personal achievement, and other factors. However, race was the single largest factor.
An applicant is entitled to 20 points based upon membership in an underrepresented minority group.
The court found that this policy violated the Equal Protection Clause of the 14th Amendment.
The university's current policy, which distributes 20 points to every underrepresented minority applicant solely because of race, is not narrowly tailored to achieve respondents' asserted interest in diversity.
Unlike the Harvard policy, which Justice Powell endorsed, Michigan's
automatic distribution makes race decisive for virtually every minimally qualified underrepresented minority applicant.
The vote in Gratz was 6-3. Chief Justice Rehnquist, joined by Justices O'Connor, Scalia, Kennedy, Thomas, and Breyer, found the undergraduate policy unconstitutional. Justice Stevens, Souter, and Ginsburg dissented. However, the vote in the other case, Grutter versus Bollinger, went 5-4 the other way. Justice O'Connor, joined by Justices Stevens, Souter, Ginsburg, and Breyer, found the law school's admission policy to be constitutional. In dissent were Chief Justice Rehnquist and Justices Scalia, Kennedy, and Thomas. Why was the University of Michigan's undergraduate policy set aside, but the law school policy upheld? Instead of assigning a numerical value to an applicant's race, as did the undergraduate policy, the law school considered race as one of many factors. Justice O'Connor determined that
the law school considers race only as a plus in a particular applicant's file and gives serious consideration to all the ways besides race that an applicant might contribute to a diverse educational environment.
Specifically,
the law school engages in a highly individualized, holistic review of each applicant.
Furthermore, she explained that
the law school's pursuit of a critical mass of underrepresented minorities operates neither as a quota nor a two-track admissions system.
Study guide. Is there a specific number of minority students that would constitute a critical mass? If so, how is that number different from the quota in Bakke? If not, how can the university ever know that such a critical mass is reached? The 5-member majority adopted Justice Powell's diversity rationale from Bakke. It held,
the law school's use of race in admissions is narrowly tailored to further a compelling state interest in assembling a diverse student body.
Study guide. Are you persuaded that Justice O'Connor was indeed applying strict scrutiny? Justice O'Connor admitted that
race-conscious admissions policies must be limited in time.
Study guide. How do the majority and dissenting justices in Grutter disagree about the proper use of racial classifications? We will consider this question in our discussion of Fisher versus University of Texas, 2016.